Graeme Samuel, you've effectively declared war against the big four banks on any more mergers and takeovers. Why?
What we've said is that if there are to be any more mergers or takeovers in the banking sector, there needs to be a very careful, rigorous analysis. Look, there is no secret that since the global financial crisis has hit us, that the big four banks have become more dominant in the Australian finance sector. The regional banks have had some difficulty, particularly in raising wholesale funding, and the non-bank financial institutions have, as I've said before, gone into hibernation. And that raises some really serious issues. You know, business at the moment is complaining, and look, we're very wary, of course, of the anecdotal complaints about margins being sought by the big four, but what is happening is that there is less and less choice. Small businesses having its difficulties, big business, of course, can look after itself, particularly in the international market. But there are some really significant issues that are starting to coming out in the home lending market as well. And I think what we need to do is to be sure that Australian consumers, Australian businesses, small businesses and the like, have got a choice.
But what are you saying is their position now?
What's happening at the moment is the big four banks are becoming more dominant. Their market share is increasing. As their dominance is increasing, so we have a greater degree of concentration of financial power, of lending power in those four major banks. There is less competition than what we've had in the past. Now, I'm not alone in saying that. Ian Macfarlane, the former Reserve Bank Governor, indicated that in certain respects he thought that what we had was less than intense competition. I call it workable competition, but it's not the intense competition that we would like to see as consumers, as borrowers.
But there may be more, there will be more takeover proposals or merger proposals. Can you stop them?
Yes, we can, if they are likely to lead to a substantial lessening of competition. That's the law. And the law says that any merger that is likely to lead to a substantial lessening of competition can be stopped. Now, how do we determine that? Well, when we looked at CBA Bank West, it was very difficult because looking at the likely state of competition in the banking sector at that point of time was very hard indeed. We normally put a 2 to 3 year time frame on the word likely. But in those circumstances, I'm not sure you could have put much more than a 2 to 3 month time frame in the context of government policy changes, international policy changes, the whole potential, as it was put at that time, for a global financial meltdown. So they're the sort of issues we had to deal with then. If we're looking at a merger now, we would be taking a far calmer, far more rigorous analysis of the potential for competition in the market in the future. What will be the role of the non-bank financial institutions, of the regionals, of foreign banks, of the major banks? How will they all interrelate? What might be policy changes on the part of the Australian government or international policy changes? How are they going to exit from some of the policy prescriptions they put in place in the context of the global financial crisis? You know, the government guarantee of bank deposits. All those issues will be relevant.
Are you saying there will be a big inquiry by the ACCC?
If I use the word major inquiry, it suddenly becomes ACCC to head major inquiry into the financial markets.
But that's what you're saying.
Well, no, what I'm saying is we'll conduct a very rigorous set of inquiries, as we must do in any merger. But in this case, we're now dealing with a highly complex industry that is dealing with some very uncertain policy prescriptions into the future. We certainly don't know what government is intending to do with the policy prescriptions they put in place in the context of the global financial crisis. I'm not sure the government has made up its mind, but these are all factors we'll take into account.
Is this a shot across the bow of potentially the ANZ and NAB, because they would be the likely buyers of Suncorp's banking assets?
No, it's a shot across the bow of anyone that's considering a merger to say, don't think it will be dealt with in a matter of 2 or 3 or 4 weeks with a superficial analysis. Don't think you can put a superficial submission to us that says we had better be able to take over this particular business or this particular financial institution, because otherwise there might be some difficulties with the financial institution that's the target and the like. We want to see a lot more than that. It's simply saying there will be a very rigorous analysis undertaken. And I think that the Australian community and Australian business would expect that of us.
But why didn't you do that when CBA took over Bank West, and indeed when Westpac took over St George? Why give both those the big tick?
Well, Westpac St George, we did conduct an analysis. Remember, that was pre-GFC, so no one at that time was predicting the collapse of Lehman Brothers or the GFC hitting the way it hit the world, almost like a tsunami. And we cleared that because our view was that St George was not providing and would not in the future provide a competitive tension that meant it was a substantial or significant contributor to competition in the banking market. And we analysed that, we put out a statement of issues and we reached a conclusion. CBA Bankwest was different. There we were at the very peak of the financial panic, the worldwide financial panic in respect of the financial system. All the discussion, all the talk, not just from the media, but from central bank governors, was that we were potentially facing a financial meltdown. And here we had a circumstance of a wholly owned subsidiary of a bank, HBOS, in the UK that had got itself into serious trouble, and that was quite clear, and we had proper official information as to that. And the question was, if that HBOS parent was no longer going to be able to provide the $16 billion of wholesale funding to Bankwest that it had on its books at that time, what then was going to be the future of Bankwest in the banking market? The short answer was APRA, Reserve Bank advice, and our own analysis was that Bankwest was going to contract substantially, might have even imploded.
So how much pressure did the government or APRA or the Reserve Bank put you under to allow that merger to go ahead?
Government had no involvement at all. The government has never communicated with us a view on these matters.
Well, those other bodies?
Well, APRA and Reserve Bank certainly gave us very strong advice that said that Bankwest needs to be dealt with, and needs to be dealt with quickly, that is facing a critical problem in terms of its parent in the United Kingdom, and at the same time, if Bankwest were to get into serious difficulties if it were, that might have an impact on the stability of the financial system in Australia. Now, we had to take all that into account.
Did they effectively say, let this merger go ahead?
I don't like to put it in those terms because they don't direct us in that form, but they gave us very strong advice, and you don't disregard the advice coming from bodies as significant in the financial sector as the Reserve Bank and APRA.
So you allowed an anti-competitive merger?
Yeah, I think there's no question. This was a merger that in our view, in normal circumstances, would have been anti-competitive, but I have to emphasise this. The fact of the advice given to us as to the withdrawal of wholesale funding, the fact that withdrawal of wholesale funding would have led to a major contraction of Bankwest, put it into a position where I think we were able to conclude that Bankwest was no longer going to be, in the absence of this merger, a competitive force in the market. It may have even disappeared from the market, and that was a factor we had to take into account.
But St George Bank wasn't under any threat of failing. Why did you allow that when it lessened competition?
Well, no, it wasn't. See, St George Bank, we analysed that, and we put out, in fact, a statement of issues on St George Bank that simply said this: in the institutional funding market, institutional lending market, this was an international phenomenon, and St George Bank was but a minnow in that area. In terms of the Australian domestic market, St George Bank's costs of funds and its market share was such that, in our view, it was not a significant competitive force in the marketplace. And whether it was on its own or whether it was merged into Westpac, it wasn't going to have a substantially anti-competitive effect. Let me underline those words: substantially anti-competitive effect, which is the law that we have to deal with under Section 50. We did deal with some issues relating to funds management. We put that in our statement of issues. We received further submissions on that. We were able to clear it on the basis there was no anti-competitive elements in that.
Now we find ourselves in a position where even the Reserve Bank is saying that, and you've said yourself, that banks have substantial market power and that has been growing. Do you feel responsible in some way for allowing that situation to happen?
No, because that situation's arisen for factors totally unrelated to the merger of St George into Westpac and the merger of Bankwest into CBA. That's arisen as a result of the global financial crisis, policy prescriptions that have had to have been taken in Australia and overseas that have impacted upon the sources of wholesale funding, the cost of wholesale funding, the availability of retail funding, of retail deposits to the banks, and the fact that in this country the four majors have had a cost of wholesale funds that's been significantly less than the regionals in terms of access to the government guarantee of those wholesale funds, and that in itself has had its own impact on their ability to engage in competitive lending practices. So this, I think we would all say, and I think if you spoke to the Reserve Bank, to APRA and to other observers in the market, they would say the mergers have had a minimal impact. What's been the real issue here has been the global financial crisis and the fact that the more highly rated banks, the four majors in Australia, have been able to attract more funding and as a result have been able to engage in more lending business on more aggressively competitive terms than the regionals. The non-bank financial institutions, of course, have gone into hibernation. They are almost non-existent.
On the other hand, these big four banks are now an even stronger market force than they were. So you really can't stop them, can you, this market concentration?
Not at the present. We can't stop it in the sense that the competition regulators in this country don't have the ability to be able to do such as occurs elsewhere, and that is to perhaps order divestitures and the like. And let me emphasise, that's not a power that I think we want or that we'd even consider suggesting. But you've got an inexorable process currently occurring under current policy prescriptions. Now, what governments are currently looking at, and government in this country is looking at, is how do we exit those policy prescriptions put in place for the purposes of the global financial crisis? What can we do, recognising that there may be some future issues in terms of the structure of the industry that have got to be dealt with to bring more competition back into the industry? Let's remember, the NBFIs, the non-bank financial institutions and the regionals were providing some serious competitive dynamics, particularly in the home lending market in certain areas in the past. St George Bank wasn't. Bankwest certainly was in Western Australia. Now what we have to look at is how do we restore the situation where that might happen into the future.
The People's Bank, an idea that came up this week from those six well-known economists. If you want added competition, why are you against this idea?
Well, I haven't said I'm against it. What I've said, this is entirely a matter for government, but I look upon it with some cynicism, if you like. First of all, let's make it clear. If you look at the 5 pages of the open letter that was provided by those 6 economists, there's but one paragraph that in somewhat, how do I describe it, somewhat veiled terms, talks about a deposit-taking institution that might then use its funds to invest in the future fund. So
why is that such a bad idea?
Well, let me get onto that. Now that's been labelled the People's Bank, and I fully expect the media might do that, and I'm surprised that the economists are surprised that that happened. That's what happens. All the rest of the questions they've asked, I might say, in those remaining 4.5 pages are very important questions that need to be asked in the context of the future of competition in the banking market. But here's this People's Bank. So it's gathered its own currency and provided its own diversion from the fundamental message of that letter. So be it. Why am I a bit cynical about People's Banks? Because we've spent 2 decades, I guess, working in trying to deal with 2 phenomena in terms of People's Banks, government-owned banks. One has been disposal, sale, and particularly we saw that with the Commonwealth Bank. And the other has been dealing with a series of royal commissions and inquiries into why these People's Banks failed. Now, do we want to get back into that state again? The problem is that when you set up an organisation of that nature, you either take a view that it's going to be artificially structured in terms of its business operations to provide an artificial competitive environment, an artificial competitive discipline and constraint.
So being more competitive than the current.
Now, if it's going to be artificial, then you've got to ask yourself, what is it doing? Where does the artificiality come in? Is it through political influence? Is it through engaging in non-commercial arrangements? Artificially low interest rates on loans or artificially high interest rates on deposits? Is that what it's all about? If so, then you've got to say to yourself, is that the best way of dealing with competition? Or do we rather look at restoring the competitive dynamic in its true intense form into the financial market? I think anyone that's been involved in a Royal Commission of Inquiry or any other form of inquiry into the failed state banks and the failed People's Banks of yesteryear would say, don't go down that route.
You're going to criminalise cartel behaviour from July 24th. Why and how afraid should business be?
Why? Because it will deal with cartel participants in the way they ought to be dealt with. Cartel participants are simply thieves. They're thieves who normally carry briefcases. There's no other way to describe them. You see, we put people in jail for evading tax, that is stealing from the Australian community through the tax office and tax. We put people in jail for stealing from the social welfare departments. But we don't put business people in jail for stealing from consumers by rigging prices, by rigging bids for, it might be for hospitals or for building schools or for building shopping centres. We simply say to them, well, if you get caught...
Or packaging.
Or packaging, yeah. What we say to them is, if you get caught, then you can get out of this by writing a cheque. That's as simple as that. And the cheque is most often far less than the amount that's been stolen as part of the process of the cartel. Now, internationally it's been recognised that these people are thieves. They should be put in jail. And the Australian government has recognised that and has said, yes, they should be put in jail for up to 10 years if they're involved in serious, hardcore cartel activity. How afraid should businesses be? Well, let me ask you this. When they know that there is a process in place which says to cartel participants, if you're the first to come and tell the ACCC about this cartel, and you're not the ringleader in relation to the cartel, you'll get immunity from prosecution.
Well, how fair is that?
Well, just a minute. I'll come back to the fairness of that. And then we're saying, and if you give us full cooperation, tell us about the cartel, the other participants might be put in jail. If I was the other participant, I'd be really worried indeed. I would say the risks associated with one of my cartel conspirators coming to the ACCC are so great. The risk of my going to jail for up to 10 years is so great, I think I better be the first in the door to tell the ACCC. We have a whole range of serious investigations going on at the moment. They won't be criminal investigations because they're under the civil jurisdiction. Almost 90% of those as a result of whistleblowers coming in and telling us under this immunity policy. Now, you ask how fair is it, the immunity policy? It was actually one of the first questions asked of me when I joined the ACCC back in 2003. Someone said to me, a business person said, that's very un-Australian, isn't it? Encouraging business people to dob on their mates. My response was to say, no, it is far more un-Australian to be stealing from your fellow Australians money through the operation of a cartel. And that is what a cartel is. It is simple theft.
Will big business be able to buy their way out of a criminal action?
No, on no account at all. If we decide that a cartel is a serious, hardcore cartel and therefore worthy of criminal prosecution, we'll work with the Commonwealth Director of Public Prosecutions closely, we'll investigate it, and we will not on any basis countenance any suggestion that the business concerned or its executives can buy their way out. So if someone comes into the room and says, look, we understand you're criminally investigating this cartel, we are prepared to pay double the penalty. I'll simply put up the hand. Our people will put up the hand and say, stop. We are walking out of the room. You will not negotiate your way out of jail, no matter how fat your chequebook and no matter how much you want to try and fight us. Our determination is to put these people into jail if they're engaging in serious hardcore cartels.
But your case will have to stand up now in front of a judge and jury.
Correct, and that's the burden of proof. It's the appropriate burden of proof.
You were roundly criticised for pursuing Richard Pratt over the criminal case. Did you push that too far, given that he had been publicly humiliated over the civil case and he had to pay a massive fine for cartel behaviour?
I've refrained from commenting upon the Richard Pratt matter because he got into an emotional environment, if you like, particularly with his ill health and then subsequent death. But let me just simply point out this, that whenever the ACCC considers a criminal prosecution, it does not make that decision on its own. The ultimate decision as to whether or not a matter should be the subject of a criminal prosecution is taken by the Commonwealth Director of Public Prosecutions. And he has two tests that he has to apply. The first is, does he have reasonable prospects of securing a conviction based on the evidence that's laid before him by, in this case, the ACCC? The second test he applies is it in the public interest that a criminal prosecution should be pursued? Now, the DPP has said in many occasions he does not make those decisions lightly. I doubt that he made the decision in this case lightly.
Did you jeopardise the ACCC's credibility over that issue? That was an unusual move.
No, it wasn't an unusual move. See, we have already, in several matters of recent years, taken individuals to criminal prosecution for having given us information that we consider was misleading in relation to Section 155, that is our investigation powers. Look, a real estate agent up in the Blue Mountains was prosecuted and he received a 6-month community service sentence and a conviction. We put another person in jail in relation to matters like this. Now, these are small business people. I'll leave it to you to determine whether we should start distinguishing.
On the other hand, you've been pretty fearless as the ACCC chairman. Did you suffer over the Richard Pratt issue, particularly in your hometown of Melbourne, where Richard Pratt was lionised after his death?
Look, I won't comment on that. I just don't think it's appropriate. Well, I just don't think it's appropriate, Helen. Look, these are
There's enough space between.
No,
the death
I just don't think there'll ever
there?
be enough space. The position is this: is that the ACCC, the commissioners of the ACCC, and in particular the chairman of the ACCC, take on a role which they must administer in a fearless fashion, without fear or favour for any person. We do so in the public spotlight, particularly the chairman of the ACCC. Now, there are costs associated with that, and they're the sort of costs that I have to bear. So be it. I've been in public life enough with the Australian Football League and various public duties to understand that public life has its costs. It also has its rewards, because in the end, you can step back and say, well, I've done something. I've worked with my fellow commissioners to do something that has helped the Australian community.
Did you lose friends over that issue?
I won't comment.
You've taken on anti-cartel behaviour as a major crusade, but do you sometimes get too zealous and get it wrong? For instance, the ACCC case against Patrick's boss, former boss Chris Corrigan and P&O. Now, they came to an arrangement, they've paid a small fine, but the judge in the case said that their arrangements were known, they weren't secret, the market knew about them, and that it was quite different to normal cartel behaviour. Did you get that one wrong?
No, I don't think we did. I mean, there was a $3.8 million fine plus several $100,000 of our costs that were paid by the companies concerned, P&O and Patrick. There's a whole lot of issues that arise in relation to these court cases involving tactics and strategies, particularly on the part of respondents. And so it makes it very difficult for me to comment as to what has occurred. And sometimes we have to wear the commentary that comes from media commentators, sometimes even the one-line commentary that will come from one of the respondents.
But they didn't admit liability, so in a sense you did not win.
Well, let me say that when you get a $3.8 million penalty, I think you can regard that as a pretty fair indication that there was something amiss that had to be dealt with. There have been various commentaries that, well, it was simply the absence of seeking an authorisation. I don't want to comment any more on the matter because the matter has now been heard and determined by the court. Safe to say this, that the case was taken, it was instituted on the basis of our view, based on all the advice we had, that we had reasonable grounds for instituting the proceedings. We obtained court orders that there was conduct that had occurred that was likely to lead to substantially anti-competitive consequences, although there was no finding as to whether those anti-competitive consequences had occurred. And there was a $3.8 million fine that was paid, as well as costs. Now, others will have to judge those things. I know that it's very attractive for the media to get one-line grabs from various executives that, talk about, as again in this case, talked about Graeme Samuel's ACCC and this just vindicated, etc., etc. I simply observe this, that in this area, we have to deal with a whole lot of strategies and tactics involved. It is very difficult to deal with respondents that are out of the jurisdiction of Australia, that are outside the jurisdiction of the ACCC, and I will simply make that observation.
You've just launched federal court action against Cabcharge, alleging abuse of market power. What chances do you hold for winning that case?
Well, I won't comment. We don't comment upon matters that are before the court, so it'd be most inappropriate for me to be saying that to the judge in that case, Your Honour, we brought this case before you. I think that whatever you might ultimately decide, we've got a certain chance of winning this or a certain chance of losing. So let's just wait and see what Justice Finkelstein deals with in that case.
All right, well, in a more general sense, what's the difference between Cabcharge's growth of market power and your alleged abuse of market power, you say, by them, and Woolies, who use their market power to undercut competitors, things like that?
What we've alleged in the cab charge case now, so I don't want to comment upon the matter, so I'll simply quickly summarise, but the allegation is that the processes adopted by cab charge in that case amounted to breaches of section 46 in particular, which is the abuse of market power. Now that goes beyond simply buying up or expanding your business, either organically, that is expanding just by normal growth, or expanding by simple acquisitions. Abuses of market power relate to issues such as predatory pricing and the like, and they're the sorts of matters that will be determined in the cab charge case.
And Woolies never does that?
Well, you know, I don't want to start commenting about whether Woolies does or doesn't do things, because yeah, we're constantly subjected to a barrage of complaints about the major supermarkets, and we look at all of them, but we do subject them to a fairly objective analysis. I think cab charge is interesting in in the sense of the legal profession and business generally, because it is the first major case we've taken under the partly revised section 46. Misuse of market power provisions, and so it'll be interesting to see the way the court interprets those provisions as they've now been amended.
Graeme Samuel, thanks for your time.